If you are waiting for your green card, your work permit, your visa interview, or any kind of USCIS decision right now, please stop everything you are doing and listen to this entire video. What I am about to share with you today could affect millions of immigrants across the United States. There is a deadline quietly ticking in the background. There are new rules already in effect, and I can tell you right now, most people have no idea this is happening. If you do not understand what changed and what you need to do in the next few weeks, you could lose your status, your work authorization, or even your chance at a green card. So please, stay with me for the next 15 minutes, because this is one of those updates where every second of information matters. Let me start with what just happened. The March 2026 Visa Bulletin reflects significant forward movement across multiple employment-based preference categories, particularly for India and China, and marks the return of EB-2 All Chargeability areas to current status. Do you understand what that means? If you are from almost any country in the world and you have an approved I-140 petition in the EB-2 category, your filing date may now be current. That means you may be eligible to file your I-485 adjustment of status application right now, this month. EB-1 advances 1 month for China and India, and all other countries continue to be current. EB-2 shows no movement for China, but India advances 2 months to September 15th, 2013, and all other countries advance to October 15th, 2024. EB-3 shows all countries advance except for China mainland, which remains at May 1st, 2021, and India, which remains at November 15th, 2013, while the Philippines advances 2 months to August 1st, 2023, and all other countries advance by 4 months to October 1st, 2023. Now I know those sound like just numbers and dates, but let me tell you what this really means for you and your family. While overall processing may be delayed, filing now allows cases to enter the queue and enables applicants to receive employment authorization documents, known as EADs, and advance parole travel authorization while awaiting green card approval. That is huge. Even if your green card is not approved tomorrow, filing your I-485 right now means you can get a work permit that is not tied to your employer. You can get travel documents so you can leave and come back. You gain flexibility, you gain freedom, and you gain protection. Employers with foreign nationals who were previously ineligible to file adjustment of status applications should reevaluate eligibility immediately, as this month's advancements open new filing opportunities. If your employer has not told you about this, you need to reach out to them today. Do not wait. Tell your HR department. Tell your immigration lawyer. Because this window may not stay open forever. And here is why I say that. But listen carefully, because this is the part nobody is talking about. Former Visa Office Chief Charlie Oppenheim suggests this month's bulletin is less about movement and more about strategic positioning for the remainder of fiscal year 2026. The government appears to be advancing filing dates to build a reserve of applicants while preserving flexibility to potentially make certain preference categories current later in FY 2026 and to avoid end-of-year visa waste. What does that mean in simple English? It means the government is opening the doors wider right now, so they have a big pool of applications ready to go. But here is the risk. The March 2026 Visa Bulletin itself states that as additional immigrant visa demand materializes or administration actions are amended, retrogression may be necessary later in the fiscal year to keep issuances within annual limits. Retrogression means the dates move backward. That means if you wait too long, if you hesitate, if you say you will do it next month, the door could slam shut, and you might wait years before it opens again. Organizations that move quickly to identify eligible cases and prepare filings now will be better positioned to capture near-term opportunities while mitigating the risk of retrogression later in FY 2026. This is not me guessing. This is what top immigration law firms across the country are telling their clients right now. Now let me talk about something that affects a completely different group of people, but is equally important. There is a rule that has been around for years, but right now, in this environment, it has never been more dangerous to ignore. It is called the 90-day rule. The 90-day rule states that temporary visa holders who marry or apply for a green card within 90 days of arriving in the United States are automatically presumed to have misrepresented their original intentions. So if you came to America on a tourist visa, on a student visa, on any single intent visa, and within those first 90 days you got married to a US citizen, or you filed for a green card, or you started working without authorization, USCIS can presume you lied about why you came. It is a simple rule, but applicants who get it wrong could find their green card applications denied and their current visas revoked. They could also find it hard to obtain US visas in the future. I know people who lost everything because they did not understand this rule. They came on EB-2 visitor visa, they fell in love, they got married, they filed for adjustment of status, and USCIS said no. You planned this all along, you committed fraud. And just like that, they were in removal proceedings. Misrepresentation under the 90-day rule can result in a lifetime ban from entering the United States. A lifetime ban, not 5 years, not 10 years, a lifetime. So please, if you are on a temporary visa right now and you are thinking about getting married or filing for a green card, talk to an attorney first. If you are on a single intent visa and you change your mind about staying permanently after arriving in the country, you should wait at least 90 days before applying for a green card or marrying a US citizen or permanent resident. And even after 90 days, you still need strong evidence that your original intent was genuine. The rule does not apply to dual intent visas, such as H-1B or L-1, which allow you to seek permanent residence while on a temporary visa. So if you are on an H-1B, you have more flexibility. But if you are on an F-1, a B-1, a B-2, a J-1, you need to be extremely careful. Now, if you are finding this video helpful, I need you to do something for me right now. Hit the like button. I am not asking just to ask. The algorithm on YouTube pushes this video to more immigrants who need this information when you like it. You might help someone who is about to make a terrible mistake. And please comment below with your visa type and your priority date. I read every single comment, and I try to address the most common situations in my next videos. And if you are not subscribed yet, subscribe right now and turn on that bell notification, because I am posting daily immigration updates. And in this environment, missing one video could mean missing a critical deadline. Now let me get into something that is shaking the entire H-1B community to its core. On October 21st, 2025, USCIS released additional information regarding the $100,000 H-1B fee mandated by presidential proclamation. Employers seeking to employ an H-1 worker who is abroad using an H-1B petition filed after September 21st, 2025 must pay an additional $100,000 fee. $100,000. That is not a typo. That is not an exaggeration. That is a real fee that is now being enforced. The largest clarification is that the fee will not apply to petitions filed as a change of status or extension or amendment of stay for individuals already present in the US. So if you are already here in America, already in H-1B status, or changing from F-1 to H-1B, you are most likely not affected. But if you are outside the United States and a company is trying to bring you in on a brand new H-1B, your employer must pay this $100,000 fee on top of everything else. USCIS has confirmed that the 2026 lottery will require the $100,000 payment unless it grants a national interest exception, as this will be considered a new petition. Now, some employers are going to say, we cannot afford that. And some employers will simply stop sponsoring H-1B workers from overseas. That is the reality. The U.S. Chamber of Commerce has sued the Trump administration over the foreign worker visa fee, calling it unlawful. So there are legal challenges. There may be changes. But right now, this fee is in effect and being enforced. And here is another critical update you need to know. Stop everything for a second. This next part could determine whether you can work in this country or not. USCIS has announced enhanced screening measures across several benefit categories and reduced the maximum validity period for certain employment authorization documents to 18 months. Although this does not eliminate work authorization, it increases the frequency of renewals and the risk of gaps if filings are delayed. So if you have an EAD, a work permit, you used to get it for 2 years or longer. Now it might only be valid for 18 months. That means you need to file for renewal earlier. You need to plan ahead. Because if your EAD expires and your renewal is not processed in time, you cannot work. You sit at home. Your bills pile up. Your life stops. USCIS also announced the creation of a new USCIS vetting center to centralize the enhanced vetting of applicants. The center will be responsible for screening terrorists, criminal aliens, and other foreign nationals who may pose threats to public safety or who have engaged in fraud or other criminal activity. What that means for regular, honest, hardworking immigrants is more scrutiny, longer processing times, and more requests for evidence. So you need your documents to be perfect. Every single form, every single page, every single signature. Let me now talk about something that is affecting people from dozens of countries. Effective January 21st, 2026, the Department of State paused all visa issuances to immigrant visa applicants who are nationals of a long list of countries. Earlier this month, the Department of State announced it was pausing immigrant visa processing for an additional 75 countries. This includes spouses and kids of U.S. citizens and brings the total number of nationalities banned up to 93. Think about that for a moment. 93 countries. If you are from one of those countries and you are waiting for an immigrant visa at a U.S. embassy or consulate, your visa issuance is on pause. Immigrant visa applicants who are nationals of affected countries may submit visa applications and attend interviews, and the department will continue to schedule visa interviews. So you can still go to your interview. But even if everything goes well, they may not stamp your visa. They may just hold your case. No immigrant visas have been revoked as part of this guidance. So if you already have a valid visa, you are okay for now. This pause is specifically for immigrant visa applicants. Tourist visas are non-immigrant visas and are not affected. But imagine this. You are a wife waiting in your home country. Your husband is a U.S. citizen. He filed a petition for you. You did everything right. You gathered every document. You went to your interview. And then they told you, we cannot issue your visa right now. We are reviewing. We do not know when. That is the reality for families from 93 countries right now. It is heartbreaking, and it is real. Now let me talk about asylum seekers, because there is a proposed rule that could change everything. DHS proposes to exclude from ED eligibility any alien who entered or attempted to enter the United States without inspection on or after the effective date of the final rule, unless the alien expressed to an immigration officer an intention to apply for asylum within 48 hours after entry. USCIS anticipates that this rule would result in an initial and potentially lengthy pause. USCIS anticipates that this pause would be instituted after they reviewed average asylum application processing times for the first 90-day period after the rule took effect. If you are an asylum seeker waiting for a work permit, this proposed rule could delay or even block your ability to get one. Comments on this proposed rule must be received on or before April 24th, 2026. That means you still have time to make your voice heard. Talk to your attorney. Look into submitting a public comment. This is your right. Now let me also talk about the H-1B lottery that is happening right now. On January 30th, 2026, USCIS announced that the online registration period for H-1B quota selection will begin on Wednesday, March 4th at 12 o'clock noon Eastern Time, and will run through 12 o'clock noon Eastern Time on Thursday, March 19th. If your employer has not registered you yet, time is running out. The main change to the H-1B registration process this year is that USCIS has implemented a weighted lottery system, which will give higher-paid applicants a greater chance of selection. So if you are in a higher-paying position, your odds may have improved. But if you are in an entry-level position, this new system could work against you. Employers with selected cases will then be eligible to file an H-1B petition with USCIS within a designated 90-day period following registration selection. That is another 90-day deadline you cannot miss. If your employer is selected and does not file the petition within that window, the selection is wasted. Gone. Done. No second chances. Let me also give you some very important practical advice. If you are in any kind of immigration process right now, whether it is a green card, a visa, a work permit, naturalization, anything, here is what you need to do immediately. First, go to the USCIS website and check your case status today. Not tomorrow. Today. Write down your receipt number, your case status, and the date of the last update. If nothing has changed in months, that could be a problem. You may need to submit a case inquiry or contact the USCIS contact center. Second, submitting applications with missing information, incorrect details, or insufficient supporting documents is a leading cause of rejection. Every field must be completed accurately. Go through your application right now. Check every page. Make sure nothing is missing. Third, hiding or omitting information, especially regarding past legal issues or previous immigration attempts, can be considered misrepresentation and lead to severe penalties, including bars to future immigration benefits. Be honest. Be completely transparent. USCIS has access to more databases than ever before. They will find inconsistencies. Fourth, immigration laws change rapidly. Using old forms, instructions, or legal advice can lead to denials or delays. Always verify information is current for 2026. Do not use a form you downloaded 6 months ago. Go to the USCIS website and download the most current version today. Fifth, if you do not have an immigration lawyer, get one. I cannot stress this enough. Strict deadlines apply to all immigration filings. Missing a deadline, even by a day, can result in your case being closed or denied, with limited options for appeal. A good lawyer can save you years of waiting, thousands of dollars, and the heartbreak of a denial that should never have happened. And sixth, if you are an H-1B worker, you should refrain from international travel while your petition is pending. Departure from the United States while a change or extension of status petition is pending may cause USCIS to determine that the change or extension of stay portion of the petition has been abandoned. Do not risk it. One trip could destroy your entire case. Now let me paint a picture so you can understand how serious this moment is. Imagine you are an Indian national in the EB-2 category. You have been waiting for your green card for over a decade. Your kids grew up here. They speak English better than your native language. Your whole life is here. And now, for the first time in years, the visa bulletin moves forward almost a full year for your category. This might be your moment. But if you do not act right now, if retrogression hits next month, you go back to waiting. Maybe for years. Maybe longer. Or imagine you are a student on an F-1 visa. You just graduated from an American university. You got a great job offer. Your employer wants to sponsor your H-1B. But the new weighted lottery system and the $100,000 fee for overseas applicants are changing the landscape. You need to understand your options. You need to know if you are exempt from the fee. You need to have a backup plan. Or imagine you are a spouse of a U.S. citizen waiting for your immigrant visa in one of those 93 countries that are now paused. Every day you check your email. Every day there is nothing. Your children miss their father. Your family is separated by an ocean and a policy. You did everything by the book, and now you are in limbo. This is the reality of immigration in America in March 2026. It is a time of opportunity for some and a time of uncertainty for many. And the difference between those who succeed and those who fall through the cracks often comes down to one thing: information. Knowing what changed, knowing what to do, knowing when to act. So please share this video with anyone you know who is going through the immigration process. Share it in your WhatsApp groups. Share it with your family members overseas. Share it with your coworkers who are on visas, because this information could change someone's life. Before I let you go, I want to tell you something from the heart. I know how hard this process is. I know how much you have sacrificed. I know you lie awake at night wondering if everything is going to be okay. And I want you to know that this channel exists for you. Every single day, I am going to bring you the latest updates, the most important changes, and the clearest explanations I can give you. But I can only help you if you are here. So subscribe. Turn on that bell. Drop your comment right now telling me your visa category and what country you are from. I want to know who is watching. I want to make videos that speak directly to your situation. And like this video if you got value from it. Now here is what I need you to remember. We are in the middle of the fiscal year. Everything can change next month. The April 2026 visa bulletin could bring massive retrogression, or it could bring even more forward movement. New executive orders could drop at any time. Court decisions on the $100,000 H-1B fee could change the game overnight. The proposed asylum work permit rule could be finalized. And if you are not watching this channel when those announcements break, you could miss the one piece of information that determines whether you stay in America or not. This is not the time to look away. This is the time to pay attention like your future depends on it. Because it does. I will see you in the next video, and trust me, what is coming next week is something you absolutely cannot afford to miss.